I'm James Kushner. I'm a deputy director of the housing unit at Gulf Coast Legal Services. Gulf Coast Legal Services is a legal aid organization. We're headquartered in St. Petersburg, but life being what it is, I actually mostly work out of the Bradenton office. So I had a nice drive today. Yeah. And I've been told to tell you that if all of you, I understand, have been given application forms, and if you want to speak with an attorney afterwards, those application forms need to be complete. So if you want to work on that during my presentation, if it's not complete, you want to finish it off, I don't mind. I might single you out just for funsies and ask you to repeat what I just said, but most likely I will let you do the work that you need to do. Okay. So now do we have a PowerPoint? I understand that there is a PowerPoint, but I usually just work from notes, and I don't necessarily sync to a PowerPoint. So we'll just have the St. Petersburg College Titans logo going forward as I talk. Yes. If you'd like to, the PowerPoint isn't extensive. There's just about like 7 slides, or like 7 or 8 slides. Yeah. And so I understand that you all are residents of the Standard, and the Standard has been through some interesting times in the past month or two, and which brings a lot of questions about the status of your tenancy, what your rights are as tenants, especially under the current circumstances, when you get to leave, when you get to stay, when you have to leave, when you basically have to stay, just to try and figure these sorts of things out. So to step back into the question of how long you get to stay, you have to start sort of a little more basic. Sort of the basic law, like what is a tenancy? Because you speak of there's a landlord-tenant relationship, and the status of what you have is called a tenancy. What is that? It's what's created when a tenant occupies a dwelling unit under a lease agreement. What's a lease agreement? Which is also called a rental agreement. It's an agreement between a landlord and a tenant providing for use and occupancy of premises. So I see a hand, yes.
I'm in the hotel.
Okay. Right. We may be getting to that because that may be a more specific question that you'll want to ask an attorney once you're in a one-on-one with them, for confidentiality purposes. Your own situation is your own situation. But it also comes around to if a landlord says you have to leave, do you have to leave? Because the answer is not always. Now, I was talking about a lease agreement. It's an agreement between a landlord and a tenant for use and occupancy of premises. Usually, if it's for a year or more, it has to be in writing to be effective and to have an effective termination date. If it's for a period of less than a year, it can be just on a handshake and spoken. So even if your agreement isn't in writing, as long as you have agreed at some point, and more likely if you act like you've agreed, and a tenant demonstrates that they act like they've agreed by living somewhere and paying money to a landlord for it, and a landlord demonstrates that they act like they've agreed by letting the people stay there and taking their money. So even if there's nothing in writing, if you're sitting there, if you're living somewhere, you're paying rent to someone, they're accepting the rent for you, there's an agreement as to how much rent is owed and how frequently it's owed, you've got a landlord-tenant agreement. Now, the thing about a landlord-tenant agreement is it's not infinite. A landlord tenancy has an end date. If it's a written tenancy, probably the end date is right there in the contract. This tenancy will expire on June 30th, 2025, or some such. If it's an oral agreement, then you just have to have talked with each other. I'll be here for 6 months. Sounds good to me. Handshake, done. What happens if you never really get around to that part of the agreement? Hey, can I rent this place for $1,500 a month? Absolutely. Is it available now? Yeah. Can I move in? Yeah. Move in. Done. Shake. Agreed upon as to the location of the premises and the amount of rent that's being paid. You'll notice there was no agreement there as to how long the tenancy was going to last. There was no definite end date. Under those circumstances, the tenancy is it's an indeterminate length, which really means under the law it's a very short tenancy. It just runs month to month. Every month is sort of a new agreement, and those can be terminated by either party, the landlord or the tenant, giving a written notice to the other party about their intention to terminate the tenancy, and it has to be at least 30 days before the tenancy would terminate. And given the rental period is from month to month, I'm assuming it's month to month. You can rent from week to week. You can rent from quarter to quarter. You can rent from year to year. Those are all possible, but most of the time around here it's month to month. And the period of the rental period is from the first of the month to the last of the month. Again, by agreement, it can be from the 15th of this month to the 14th of next month. But usually it's beginning to end. And the person who wants to terminate the tenancy has to give a written notice at least 30 days before the end of the rental period. Which means, what's today? November 7th. If we've got a month-to-month tenancy, you and I want to terminate it, I have to give you, and our tenancy is from the first of the month to the last of the month. That's the rental period. Then I could give you a written notice today, but it has to be at least 30 days before the end of the rental period. The end of November is less than 30 days away. So me giving you notice like that is only, the earliest it can take effect is at the end of December. So I give notice today, and can terminate the tenancy at the end of December. And as long as it's not for a prohibited reason, like housing discrimination based on a prohibited factor, there doesn't have to be any reason at all. It could just be that you don't like the car the tenant drives. You just feel like you want to do some renovations and you want it to be empty for a couple of months while you work on that. You want to move in your mother-in-law is coming. Your mother-in-law is going to be coming for 6 months and needs a place to stay. All of these are permissible, and that actually has a great effect, in this situation, which is to say, if there's if there's, for example, a hurricane and the place is largely uninhabitable, at worst, if the landlord wants to ask the tenants to leave and it's a month-to-month tenancy, then the landlord can just give notice and have them out probably at the end of the following month. Similarly, if the tenant wants to leave, even if there's dispute, is this uninhabitable? Do we need to? Are repairs even necessary? Assuming the place is less damaged than yours, the tenant can give notice and leave at the end of the following month. They're obliged. While the tenancy is still there, the tenant is obliged to pay rent, and the landlord's obliged to accept rent. But that's the easiest way a tenancy can terminate in Florida, which is if there's no set end date, either party can just give written notice to the other party, and it has to be for a month-to-month tenancy at least 30 days before the end of the rental period. That we'll get to that. Yeah. So the next question is, what do the landlord and the tenant have to do during the lease? The Florida statutes, there's a Chapter 83 of the Florida statutes, and particularly Part 2 of Chapter 83 are the laws governing residential tenancies. It is the Florida Residential Landlord and Tenant Act, and for the most part, that's pretty much all that define the obligations and responsibilities and rights of landlords and tenants in a residential situation in Florida. So if the answer to a question isn't in the Florida Residential Landlord and Tenant Act, there's a good chance you may be in uncharted legal territory. I mean, there may be a case that a judge has decided in a written opinion that is binding, that interprets a particular aspect of things. But for the most part, the answers are presumed to be in the statutes. So, questions are, what are the landlord's obligations during the tenancy? Well, Section 83.51 is called Landlord's Obligation to Maintain Premises. You gotta like it when the table of contents really leads it to you like that. There are some basic responsibilities that the landlord has to comply with. They have to make reasonable provisions for extermination of rats and mice and roaches and ants and wood-destroying organisms. They have to be sure that if there are common areas, they're kept safe and clean, that there's a provision for garbage removal and an outside place for tenants to put their garbage. But most importantly, they have to keep the place up to code. They have to comply with the requirements of applicable building, housing, and health codes. And so that's the major one. You know, and it could be that circumstances beyond the landlord's or tenant's control lead to what would be considered a code violation, like, for example, the roof blows off. Still, it's the landlord's obligation to keep the place up to code. And if it isn't kept up to code, then the tenant has certain remedies, which I'll talk about later. And similarly, what is the tenant's obligation? Well, that's in Section 83.52. Next one. They also have to comply with building housing and health codes, but only to the extent that they impose obligations on tenants. Generally, someone who owns a building is responsible for that building. So, but there may be certain requirements that tenants have, and that would be from the building codes. But aside from that, they're pretty general. Keep the premises clean and sanitary, remove garbage in a clean and sanitary manner, keep the plumbing fixtures clean, sanitary, and working. All the systems, electrical, plumbing, sanitary, heating, ventilating, air conditioning, elevators, if your building has an elevator, you have to use them and operate them in a reasonable manner. You can't destroy, deface, damage, impair, or remove any part of the premises or the property therein belonging to the landlord. And here's the one that landlords often cite, at least in cases when that come to mind. Conduct himself or herself and require other persons on the premises with his or her consent to conduct themselves in a manner that does not unreasonably disturb the tenant's neighbors or constitute a breach of the peace. And the word unreasonably in that section is doing a lot of heavy lifting. And basically, whenever there's a standard of reasonableness or unreasonableness, that's where lawyers make their money. Because who knows under a particular set of circumstances whether something is reasonable or unreasonable. So, we mentioned that the landlord has certain obligations, like keeping the place up to code. What happens if the landlord doesn't do that? What can the tenant do? There are basically three mechanisms under the Florida statutes. All of them are from different sections of the Florida statutes. You can all of them involve writing and the delivery of notices or delivery of something. You can deliver a notice to the landlord that says what the problems are and says to the landlord that if the problems aren't fixed within 7 days, the tenant is going to start withholding rent. So yeah, if there's big gaping holes in the roof, you can write to the landlord and say, I will withhold my, if the roof isn't fixed in 7 days, I'm going to start withholding my rent. Pretty straightforward, and you like to think that it would that hitting the landlord in the pocketbook will in fact compel some action, and it may well. But if it doesn't, there are certain risks to the tenant, because the section that talks about that is section 83.60, which is all about defenses to an eviction case. As it's basically seems to have been envisioned by the Florida legislature, what happens is the tenant gives a notice saying, if you don't fix the roof, I'm going to stop paying rent. The landlord doesn't fix the roof timely. The tenant stops paying rent. The landlord says to the tenant, you're not paying rent. gives a 3-day notice, and brings an eviction action against the tenant. At which point, the tenant brings up the notice, and the statute specifically says that the notice of the intention to withhold rent for that reason is a defense to an eviction action. And then the judge gets to decide how much rent was it appropriate to withhold. Because, it may be that you're renting a 2-bedroom apartment, and because of a roof or ceiling or leak problem, what you functionally have is a 1-bedroom apartment. A 1-bedroom apartment is not valueless. So, yep. Potentially, I mean, if it's understood that part of the rental agreement is the provision of air conditioning. In Florida, it's not actually part of the statutes, but it's generally understood as part of most rent agreements, and sometimes it's explicit. And it may come down to disclosure. If when you're first talking about renting the place, the landlord said, "I don't have any air conditioning. You're going to have to supply your own," then then you're on that. But I'm getting a time warning. I'm going to have to move much more quickly than I thought. So you can deliver the notice, and then it all comes out when the landlord brings an eviction action and the tenant brings it up as a defense, which is not so good for tenants because then it's part of the public record that the landlord has brought an eviction action against them, and future landlords sometimes don't take kindly when they find that in doing a public records search. Notwithstanding that the tenant had a complete defense, and there isn't any sort of fair housing protection for discrimination against someone who has previously been the subject of an unsuccessful eviction suit. So there's risks involved in that one. Was that a question, or you're just moving your arms? Okay, very fine. And the second possibility is it's in section 83.56. And that's delivering a notice to the landlord saying, the roof is leaking. If you don't fix this problem within 7 days, I'm going to terminate the tenancy. And the tenant does have the option to do this if they choose to. Again, it is something they can choose to use. And sometimes the landlord will say, "Yeah, I'm not going to be able to fix it in 7 days. Indeed, I may need to." Do it. I mean, to spend a couple of months working on it. Go in peace. The tricky part about that is, it loses effectiveness if it's an empty threat. If you deliver a notice like that, you need to actually be prepared to vacate, which kind of puts you on a knife edge because maybe the landlord will fix the problem within 7 days. At which point, there you are, all prepared to having left. And the landlord fixed the problem, and your tenancy is not terminated. So what from a logistical standpoint, sometimes it makes more sense to do the threatening to withhold rent rather than threatening to terminate the tenancy. And the third possibility is go straight to court. Under sections 83.54 and 83.55. If the landlord is not compliant with the requirements of the Florida statute, a tenant can bring an action in the appropriate court, possibly to get damages for the landlord's failure to do that. Damages means money, or possibly to get a court order, an injunction to compel the landlord to do whatever the repairs are, and that puts the landlord in even more trouble because not only are they then facing the potential of lost rent until things are fixed, but they may be in contempt of court, which has its own issues and its own penalties. The downside of that, of course, is it's a general rule of life that you don't go to court unless you have to, and possibly going that route violates that rule of life. So what happens if a tenant wants to terminate the tenancy? Again, I on my little notes here, there are 5 ways that a tenant can terminate a tenancy. One is by the notice I just described. You know, the roof has giant holes in it, it's leaking terribly, give a 7-day notice, terminate and vacate. The second is, and this one's probably the most relevant one here, if a casualty substantially impairs the enjoyment of the premises, the tenant may terminate the rental agreement and immediately vacate. And that's a right that the tenant has. That's under section 83.63. The Florida statutes do not give the landlord this right. And if a tenant wants to terminate a tenancy for that reason, the statutes don't specify that a tenant has to give notice. Apparently, I'll need to wrap this up real soon. But just to keep your bases covered, it's probably useful to still give some sort of notice to the landlord so that they're aware that you're actually terminating the tenancy and surrendering the premises. The third possibility is if the tenancy has no specific term, it's a month-to-month tenancy. You give notice. You give 30 plus days notice, as I described at the top of this talk. The fourth possibility is if there is a defined lease term, you can choose to not renew. There's nothing that compels a tenancy to renew under most circumstances. And the last one is by agreement with the landlord. You know, a rental agreement is a contract, and if all parties to a contract want to amend it, change it, cancel it, change a key term, if they all agree to it, they can change the contract. If you go to the landlord and say, yeah, I think I want to leave, the landlord says, yeah, I think it's a good idea, tenancy is terminated. So there's also the questions of what happens if a landlord wants to terminate the tenancy. The landlord can give the notice. If the tenancy is month to month, they can give that notice as described before. They can give a 3-day notice for a failure to pay rent, which is what I imagine a lot of you may be familiar with. If there is a violation of the lease agreement that doesn't have anything to do with the non-payment of rent, then the landlord can give a notice. If it's a really serious violation, like you tried to set the place on fire, they can just say tenancy is terminated. You have 7 days to vacate. If it's a less serious notice, like you've got a pet and there's no pets allowed under the lease agreement, the landlord can give a notice saying you have to cure this violation, and if it happens again within 12 months, then I'm going to terminate the tenancy. That's the basic way. And of course, if the lease term expires, the landlord can also decline to renew it. So that was the very abbreviated presentation. I've been told to wrap it up, and I think that I will now be taking individual consultations in one of the other rooms as needs arise. Okay. Thank you for listening to me.